Hey there, friends. Welcome back to another Legally Armed America video. I'm, of course, Paul Glasgow here. Guys, got a pretty cool one for you today. I got a special guest, Andy Marcantel with Attorneys on Retainer. I know you guys have probably seen him, at least those of you that are AOR clients. You've likely seen him in some of the videos with Mark Victor. They put together a series of videos, and they're really good, very thorough videos, and you'll want to check some of those out if you haven't seen them already. Check their YouTube channel out. Andy's going to join me today. Andy was integral in the case that I had the guest on last week, Joseph, in Brooklyn, New York, with the self-defense shooting. And Andy is the one who spearheaded that whole effort. So I had some questions for Andy that would come from more of an attorney standpoint as opposed to Joseph's angle, him being the one that actually was being represented in this case. So here's that interview with Andy, and I think you'll find that it's very interesting. Hey, Andy, welcome to the show.
Paul, thanks for having me on, brother.
Well, you know, we got a lot of buzz going with this case with Joseph last week, and obviously you guys were an integral part, and you more specifically were obviously very, very involved in this. And first of all, kudos for what I consider to be a major victory in this case with Joseph. I think after everything that you guys presented, it certainly made for a good case for us to be able to look at and go, okay, these are some do's and some don'ts going forward for us as gun owners. But you guys definitely had your hands full. Obviously, you're fighting an uphill battle being in New York and New York City more specifically. I mean, things are not in your favor there as an attorney, let alone a guy carrying a firearm. Two things that I mentioned whenever I talked to Joseph were that I felt like were two very big positives, were the fact that, number one, he hired you guys. Had he not made that switch to attorneys on retainer, he would not have had the representation. And again, more specifically, you guys, he wouldn't have had AOR. But I also had mentioned that the video, in my opinion, again, a non-attorney, I saw that as a big positive. How was that video received by prosecution when you guys ran it down and presented it to prosecution, and did it help your case?
Yeah, no doubt that video was super important. And luckily we were able to get that video. The local council recommended an investigator immediately after the incident who we were able to get hold of in the middle of the night and get them working on trying to track down this video. Because you never know who's going to have a video of the incident, right? And we were very lucky that after talking to a whole bunch of different local businesses and apartment complexes and things like that, we actually found this video at a local deli. There was a deli kind of catty corner to where the incident happened. And the deli owner, when we spoke to him, didn't even know that there was an incident that had occurred the night before, and said, oh, okay, let me roll back my camera and see if there's anything useful for you guys. And sure enough, we got that video. And yeah, that video, obviously, so important to preserve that. A lot of these surveillance cameras, you know, people have them to automatically tape over the footage on them every day, every other day, things like that. So you really, really got to act quick when it comes to preserving this evidence. But the video wasn't everything in this case, it turns out. Most people would look at that video. They see Joseph running away from this mob. They're chasing him. He's evading them multiple times. Then the guy straight up chases him down the street and is trying to grab him at the time when Joseph then turns around and fires the round. Most people look at that and say, okay, this is open and shut, clear aggressor, clear defender. This should be the end of it. Well, not exactly, because when the prosecutor saw this video, while it did check some of the boxes, right? It showed that he wasn't the initial aggressor. It shows that he had fulfilled New York's requirement to retreat, right? Because New York is not a stand your ground state. New York imposes on its citizens a duty to retreat, as ridiculous as that is. But this video clearly shows that he fulfilled that duty to retreat on multiple occasions. So the question is, okay, how does this not show an open and shut case? And the answer is because, like every jurisdiction in the United States, you are only allowed to defend yourself with proportionate force, right? The idea is that there's a couple different classes of force in the criminal law. And one of them is ordinary physical force, think fist fight kind of a thing. And the other is deadly physical force, think a gun, a knife, and various weapons. And a general rule of thumb is you're never allowed to use deadly physical force when you're confronted with merely ordinary physical force. So in this case, the prosecutor, while she saw that there were obviously some strong points for the defense in the video, had to hang up in terms of, okay, well, you got this video showing the incident, But really all it's showing is that your client is using deadly physical force in response to a guy who's chasing him down, who isn't obviously armed in the video. He's using deadly physical force in response to ordinary physical force. He brought a gun to a fist fight, as they like to throw around in prosecutors' offices. So the video is really important, but how we kind of finished telling the story there was really what we needed to do to convince that prosecutor that this use of the deadly physical force was necessary. She didn't know anything about the stabbing that had just occurred with his uncle around the corner. She didn't know anything about the fact that these guys were still armed and the fact that they were saying and doing things to indicate to any reasonable person, certainly Joseph, that they were still armed and intending to use those things. So we got the medical records from the uncle. We were able to get a full narrative of what happened. We were able to kind of put their statements, right, the alleged victims, we were able to put their statements against what the evidence was showing to show that they were lying. And this is important too, because if we tell the prosecutor, hey, your star witness, your victim in the case, we're going to have a lot of fun with them on cross-examination, because it turns out that they gave some information to the police that was not accurate. We can prove it was not accurate. And if we impeach their credibility and your whole case hangs on he said, and yours is shown to be inaccurate, you're going to have a really tough time at trial. And so it was all of those factors together, plus the video, that convinced the prosecutor, okay, this looks like valid self-defense. I'm not going to win this case at trial, even with the New York jury. And so the prosecutor agreed to dismiss the very serious felony charges, to her credit.
That's an excellent point about the uncle. Again, you have to understand, I am no attorney and I don't ever want to be one. Actually, I have very low regard for most attorneys, Andy, no offense, but I just
totally understand. Hey, lawyer jokes exist for a reason, man.
Right. That's right. But that is an excellent point, because, with me knowing everything that I already knew, it's easy to look at the video and it validates what I already know. But I guess someone who doesn't know what's really happening in the video, they just know the end result. Somebody got shot in the street, right? You don't know what led up to it. Well, we don't see the stabbing in the video. I would imagine that if this would have been some random guy who had been stabbed and you couldn't have gotten medical records or a statement from that person, that probably would have hurt your case quite a bit, right?
Well, if it was a random person who got stabbed and we had some information and could figure out who that person is, and that's another role of an investigator in a case. We deal with this all the time, where the people involved who we need those statements and records from aren't maybe friends or directly related to our client. And the court gives us mechanisms to get that, whether or not the person wants to give it to us or not, right? We have something called the subpoena power. And because our client has a right to due process, and our client has a right to defend themselves, we have the right to drag anybody into court that we need to in order to defend our client. And that includes getting access to things like records. So if we could have identified who that person was, it would have been a couple extra hoops to jump through, but we certainly would have done that in order to help defend Joseph.
But my point in this case is, what if it had been somebody who wasn't severely injured, and let's face it, maybe a rival gang member who didn't want to go to a hospital or whatever, had just self-medicated or whatever and gotten away from the scene. If you didn't have that proof that there was another victim who had been stabbed, that would have been a little bit more difficult, wouldn't it have?
No doubt. If we wouldn't have been able to get the proof that this stabbing had taken place, it would have been much harder to paint this whole narrative. But even if it had been somebody who was in a rival gang or something like that, we would have definitely turned our investigator loose on this, to start going around the apartment complex, finding everybody who was there, asking what happened. And eventually one of these people, you saw the people and their demeanor in the videos.
Oh, yeah.
They weren't exactly soft-spoken. No. And something tells me one of them would have blurted out some information that an investigator could have used to track down the people involved in that altercation.
Right. That's true. I'm curious. That's an interesting dynamic as far as his, and I'm not saying it's okay for him to have shot somebody, but with him using the firearm a little bit later on because somebody else got stabbed, is that something that you commonly see where he wasn't being attacked with the knife, but somebody there had deadly force being used against them? Is that normal to make that connection as an attorney, to say, all right, well, this was taking place over there and my client was making sure nobody else got stabbed. Is that how you guys worded it? In other words, how did you personally use that as a defense to help Joseph out?
Yeah, that's a very common tactic. And all that matters at the end of the day is what your client believes. If you take a look at all the self-defense statutes throughout all jurisdictions in the United States, they're going off of what is the reasonable belief of the person who's claiming that they legally defended themselves. So if Joseph sees somebody get stabbed, if he sees somebody in his group get stabbed, and then he sees the same people coming towards him aggressively, the law does not require him to sit there and wait until they brandish a weapon and start swinging it at him or even stab him himself before he can exercise self-defense. All that's necessary is that he's in an imminent risk of a deadly physical injury or a serious physical harm. He definitely had that here. His perception was clear. He knew what was going on. And these were the same people who had just stabbed the uncles, same people who were brandishing the weapons, now coming at him aggressively. So he had a very reasonable belief, and that's all the law requires.
So would it be safe to say, and again, I'm not trying to catch you up in this, but I'm curious, again, from a non-attorney standpoint, if I'm at a big function and somebody produces a deadly weapon, whether it's a knife or a gun, does that all of a sudden, boom, that light switch is switched on? This is a deadly interaction. And if somebody, is trying to defend themselves at that point, would the same defense be applicable here?
Probably. It's all at the end of the day, and this is going to be one of those it depends answers, right?
Sure,
it depends on what the people in the jury box think is reasonable.
I got you.
We as criminal defense attorneys get asked hypotheticals all the time. I love hypotheticals. I love talking about them where people say, well, what if this happens? Can I use a firearm in this situation? Would this action be justified in this situation? Really what you're asking me to do is you're asking me to predict what a randomly assembled jury from that jurisdiction will think is reasonable.
Right.
And we know things about people in this jurisdiction, right? We know things about people in New York. So which jurisdiction it takes place in is, really, really important too. But I can tell you this, if you see somebody brandishing a weapon, if somebody is aggressive to you, if you have personal knowledge that that person is aggressive with a deadly weapon, that's all going to come in as evidence of a reasonable belief of the defender. So I think it would put you in a good position to argue that.
Okay. And that brings up another good point from a brandishing standpoint. I know that we are certainly, all of us in the gun community are told throughout our history of carrying, well, you don't brandish your firearm. If you're going to draw it, you better be intending to use it. What if somebody, and I know these what ifs, you guys hate them as attorneys because just as the disclaimer, we're not here to give legal advice. We're just having a discussion about different situations. So if somebody were to brandish their firearm, does that suddenly make it a dangerous situation where somebody could use deadly force against that person, even if they didn't draw their weapon?
Very arguably, yes, because all that matters is, did the defender have a reasonable belief that they were at an imminent risk of deadly physical force? So we talk about this all the time. You've heard us talk about the mere words doctrine, which is if somebody just verbally threatens you, that's not enough to respond with force. But words plus action, say somebody says, I'm going to shoot you, and then brandishes a firearm, that could easily be a reasonable belief of a imminent deadly physical force or serious physical injury. So you're going to have a very strong defense in that kind of case.
Okay. Well, I mean, that's why we have you guys, AOR, to be able to fight that fight, because that's interesting dynamics that I know a lot of us never want to have to approach, but it's certainly good to know that kind of information. I know that in a lot of cases, look, let's be honest, there's a lot of gun owners out there that probably don't conduct themselves as responsibly as we would like them to. So we know that happens. To me, I prefer to give as much advice as I can that's non-attorney advice, to say, if you're thinking of running your mouth and showing a gun just to act like you're some kind of a tough guy, that's not the smart thing to do, because you may find yourself 6 foot under. I mean, that's a difficult situation.
Yeah, I couldn't agree more. And we always try to educate the public about these things. We're lawyers at the end of the day, so our job is, we're dealt a certain amount of cards, and we can't change the cards that we're dealt, right? The facts are the facts. We can uncover facts. We can paint full pictures and context for prosecutors, and we can argue things to juries, but we're dealt whatever the cards are that we're dealt. So we always try to educate the public in our videos to be as responsible as possible. Avoidance really is the best defense. Don't put yourself in this type of a situation. And it's relevant too legally because in New York, as with every jurisdiction, if you are the initial aggressor or place yourself into a situation where self-defense would be obviously necessary, then you've now lost your ability to claim self-defense.
Okay.
So every single statute for self-defense throughout the country has a little subsection usually hidden in there that says, hey, by the way, if you caused this problem or you put yourself in this situation, don't come to us and ask for a self-defense jury instruction. You ain't getting it.
Right, right. Interesting. I'm curious if you, okay, in a situation like this, what would have been your biggest hurdle if you didn't have that video? I mean, obviously knowing the video validates what we were told by Joseph, but until we see the video, we don't know that Joseph is telling us the truth. Had you not had that video, this still seems like a winnable case because he was telling the truth. What would you have needed besides, I assume witnesses, of course, but what would you have needed besides the video if you didn't have it?
Yeah, great question. And as it turns out, the vast majority of cases are not captured on video.
Right.
The video cameras at every single corner and on the lapels of the officers for body camera, and that's all a pretty recently new phenomenon. For the majority of this country's history, every single interaction didn't get captured on video, and good defense attorneys are still able to discharge their duty to their client. So what it would have been in this case, if there hadn't have been a video here, it would have really, really come down to the reliability of the witness statements, right? At that point, it really is a he said case. So all that impeachment evidence that I was referring to a little bit earlier, where you want to convince the prosecutor, by the way, your witnesses are lying. I'm going to be able to prove that they're lying. And so if it comes down to he said, my guy's just going to be more credible. And there's lots of things that are relevant to this analysis. Not only factual disputes, but also background witnesses is relevant to this. The fact that, for example, Joseph has no prior convictions whatsoever. His record is squeaky clean. And oftentimes in cases when we have a dispute over what the witnesses are saying, we will put our investigators on it to do some background checks and digging to see if we can find some things in their history that would call into question their credibility. Convictions and lying and fraud and theft and crimes of moral turpitude, as we call them, all those things can be brought in to impeach credibility in certain contexts. And we can go to the prosecutor and say, hey, we're gonna have a really fun time with your witness on cross-examination, and the jury's not going to believe them. Right. Here's why the jury's not going to believe them. So to answer your question, if the video had not existed, we would have had to impeach the credibility the old-fashioned way by interviewing people. We're entitled to interviews from every single one of these people. Save the victim. There's certain rules in jurisdictions that say you can't interview the victim directly. But all these witnesses who are there's tons of them. We start questioning them, asking them lots of questions. You do it in an isolated way so they can't hear each other's answers to it. And you start comparing them. And eventually the lies start coming out, Paul. When you start asking people individually and they can't keep their story straight, you start pulling little threads here and there, you'll see the lies start coming out. And that's really how you fight a he said kind of a case.
Okay. I'm curious on guys like Joseph who have obviously been in this type of situation where the only charge that sticks is the unlawful possession of the firearm in a jurisdiction that doesn't allow it, which is still really weird to say those words altogether, that you can't allow, it's not allowed. And this is the comment section. I'm sure you guys have looked at the comment section with Joseph. A question that's been asked to me: if for some reason a federal constitutional carry law is passed, now I know New York is going to do their New York things again. I get that. Bruin was passed and New York is suddenly declaring all these places safe places and all that, prohibited spaces. But let's just, for the sake of my argument, if there were a federal constitutional law that were passed and New York, before they got creative, were required to follow that federal reciprocity with all the other states across state lines, would that take that charge from Joseph away? Like, would he suddenly have that expunged from his record completely immediately when that law went into place?
The answer is it depends. Depends on how the law is written. Oftentimes, they'll pass a change in the law, particularly a change in the criminal statute. and they'll include some reciprocity language in there, and they'll include, importantly, some retroactivity language in there. What does that mean? That means, oh yeah, by the way, no longer is this conduct not illegal, but if you were previously convicted of this formerly illegal contact, we're going to clear your record. We're going to dump that. We're going to expunge it. And so usually they bake that into the new statute. So I would really, really hope that if there is such a law passed, that Congress would be sure to include some language in there that says we're correcting a historical injustice. And also, we want to make sure that the people who suffered as a result of this historical injustice are made right by the government. We want to clear their record. We want to make it so they can possess firearms again. Now with Joseph, he's going to be able to possess firearms again because of the deal that we got him with the misdemeanor. But there are many people who, I can't say the same for, the majority of them, finding themselves in this type of situation, find themselves deprived of their firearms rights for the rest of their life. So I really, really hope that if they were to pass such a law, there'd be some retroactivity in there where they go back and they correct all of these historical injustices.
You know, it makes me feel good talking to a firm like AOR with an attorney like you, Andy, that is now committed to defending Second Amendment cases. When you use the phrase historical injustice, that is an absolutely beautiful phrase right there, because it means way more than just a couple of words put together. And I'm serious when I'm not patronizing you. That when you said that first, I was like, wow, I'm stealing that, because it's true. I mean, it's like, how can you say that from this point forward, everything is okay when it's been wrong the whole time? There's just been a law prohibiting these people from exercising those constitutional rights. So that phrase, I'm absolutely stealing historical injustice.
Please do, my friend. It comes from the heart. It's shameful. It's absolutely shameful, the erosion of our rights in this area and many other areas. And absolutely feel free to use that term, because truer words were never spoken, in my opinion. And we're doing our best. We're doing our absolute best to fight these cases wherever we can. I would encourage people to go and take a look at our new project that we just started, where we are challenging the Commerce Clause, which is responsible for many, many injustices and erosions of freedom, including the creation of the Bureau of Alcohol, Tobacco, and Firearms. If you've ever heard of that little erosion of your freedom in this space, the Commerce Clause is the justification for the federal government imposing all of those rules on American citizens. And we're going for the throat on these new lawsuits. So everybody go check out what we're up to and support us if you can.
I'll post a link down below on that, Andy. And I want to remind the audience one more time too, that, you know, that's you guys have made a lot of recent changes at AOR. And one of the biggest ones that to me was very eye-opening to me, because I am a business owner myself, is the fact that you guys now have dedicated yourselves to focusing only on Second Amendment defense type cases. And to me, that says a lot, because there's a whole lot of legal work that you guys could be doing out there. So I have to believe at some point you're passing over work that would probably be easy money to dedicate yourselves to Second Amendment type issues, self-defense related issues. And I think that's huge. I mean, that shows me that now I'm not hiring a guy to come to my house to pull weeds, change some of the breakers in my breaker box, do my taxes. I'm hiring a guy to just fix my air conditioner. And to me, that's a huge thing. If you're going to specialize in something, that means you'll become the best at it if you're not already.
Yeah. And up until recently, that wasn't an option for us, right? When you're launching the program and you're gaining momentum, you got to still take other cases other than the ones that you're really passionate about and you want to do. But I'm proud to say that because so many people have helped bolster this program and supported us over the last year and a half, we're finally in a position where we can do what we've wanted to do for a long time, which is specialize in the one field that we're really passionate about. And it's been amazing, man. It's been absolutely incredible.
I appreciate what you guys do. And again, I'm very honored to be a part of you guys, affiliated with you. Your staff is amazing. I think that you guys' values align with a lot of mine and a lot of my viewers. So where can folks go to hear more about AOR, obviously, and to hear more about what you're talking about with the Commerce Clause?
Yeah, if people want to, well, first of all, if you want to go to our YouTube, just search for Attorneys on Retainer on YouTube, and you'll find all of our videos, including that Commerce Clause video that we recently released. If you want to learn about the program, our self-defense program, you go and check out attorneysonretainer.us. That'll tell you all about our self-defense program and how we represent gun owners throughout the United States. And then if you want to learn about the law firm, because we're not an insurance-based program, you're not talking to an insurance company when you call our program. You're talking to lawyers. You're talking to your actual lawyers who will be working on your case. And so the law firm that backs the Attorneys on Retainer program is called the Attorneys for Freedom Law Firm. And the website is simply attorneysforfreedom.com. Go and check it out. Learn all about us. You know exactly who you're going to be working with and who's going to be defending you in the justice system if, heaven forbid, you ever need to defend yourself or your family.
Sounds good. Andy, thank you for joining me today. And I appreciate your involvement with this case with Joseph. I appreciate the fact that you guys worked so hard to get him off, because he seems like a really good guy. But I appreciate you coming on here to clarify some things regarding the prosecution and how much work you guys had to put into trying to get Joseph taken care of properly. And I know he certainly appreciates you guys as well.
Joseph's a great kid, man. I'm so glad we were able to get a good result for him. Thanks for having me on the podcast, brother.
I'm sorry, I thought this was America.
He's so horrible!